Hello and welcome to today's discussion on how contingency fees will affect your final settlement payout. Most attorneys are paid by the hour, whether they're writing contracts, drafting wills, defending criminals, or advising businesses. Attorneys' fees usually begin with a down payment called a retainer and continue at an hourly rate. Compensation for personal injury attorneys is different. They don't require down payments or charge by the hour. They even pay money out of their own pockets to finance their clients' cases. Personal injury attorneys take calculated bets. They accept cases hoping they will pay off sometime in the future. Often they do, but not always. For situations like this, there are contingency fee agreements. Through advertising or word of mouth, you may have learned that personal injury attorneys aren't paid unless they win your case. If they win, you only have to pay them 1/3 of the total amount, and if they lose, you owe them nothing. This is called taking the case on a contingency fee basis. A law firm's compensation is set out in a contract called a fee agreement, which you'll have to sign. This agreement details how your attorney will be paid and the exact amounts by percentage you'll both receive when your case is over. Most personal injury clients think a contingency fee means their attorney will get 1/3 of the final settlement and that the client will get the other 2/3. But it's a little more complicated than that. There are other fees and costs that affect the amount, often lowering the client's payout substantially. By law, your attorney must tell you how her fee is earned, but you are responsible for reviewing and understanding the fee agreement before you sign it. It's a legal contract that sets out the exact amount of your attorney's compensation. Once you sign it, you are bound by its terms. Some attorneys are better than others at explaining the terms of their contingency fee agreements. Some will sit down and carefully go over each section with the client. Others give no explanation at all, simply having their secretary type up an agreement to give to the client. When you're presented with a contract, take your time and read it thoroughly. You can even take it home overnight to review it. As you do, write down any questions about legal terms or passages you don't fully understand, and don't be embarrassed. Most of the language in fee agreements is so convoluted, even some attorneys don't fully understand it. So, what are considered costs in this kind of agreement? Costs are the expenses your attorney pays while preparing and negotiating your case. The amounts normally include office and copying costs, deposition expenses, expert testimony, etc. They are deducted from the total settlement after a case is won. The costs are deducted first before the attorney takes his fee. If your attorney isn't successful at settling your case or winning it at trial, you won't have to pay any of these costs. Now, you also might have medical liens for unpaid or partially paid care and treatment. Your attorney is legally obligated to deduct and pay all medical liens before you receive any settlement money. These include medical bills from hospitals and doctors who provided treatment to you based on letters of protection, and any other providers who deferred payment for your treatment until the case was finalized. A letter of protection is a letter sent by your attorney to one or more of your medical providers, promising to pay them for your treatment. They are promised payment out of your settlement funds, or the amount awarded after a trial or arbitration. The letter of protection is a binding contract between your attorney and the treatment provider. A breach of that contract can subject your attorney to a lawsuit from the provider, as well as disciplinary action from the state bar. While reading the contract, always read the fine print. Like most contracts drafted by attorneys, there's always fine print in fee agreements. Be sure to read the entire agreement. And you should pay especially close attention to the clauses that control your payout. Remember, if you have questions about these clauses or any others, ask your attorney for a full explanation. Typical clauses found in contingency fee agreements cover the deduction of costs and medical liens, as well as the net amount a client will receive. Below, we've provided examples of typical clauses that have been simplified to make them easier to understand. Click on each title for the full text. Cost clause example, medical liens clause example, net amount to client clause example. Now, will you pay 33 or 40%? Most contingency fee agreements for settling a personal injury claim set the attorney fees at 33.3%, or 1/3 after expenses are deducted. When a claim can't be settled and must be tried in court, attorney's fees usually increase from 33.3% to 40%. You may be asking why. Well, lawsuits and arbitration require additional time and money. It can take months for a case to be tried in court, and almost as long to have it arbitrated. Preparing for trial or arbitration always requires some amount of pretrial discovery. This includes the following: preparing and filing extensive legal pleadings, attending court hearings, depositions of the at-fault party and witnesses. Depositions require court reporters who can charge anywhere from $5 to $7 per page just to take down what the deponents say. They charge additional amounts for copies, certified transcripts, court filings, etc. Court reporter fees can have a substantial effect on a law firm's overall compensation. It's not unusual for a deposition to cost over $500 per day. Expert witnesses are also expensive. Depending on the type of case and expertise required, an expert witness can cost $1,000 or more per day. Other pretrial activities include interrogatories, requests for production, legal briefs, and more. These all represent time and resources your attorney continues to spend with no guarantee of reimbursement. Let's look at an example of a fee breakdown at 33.3% of a settlement. So your total gross settlement amount is $15,000. Then there's some attorney copying costs and court reporter bills. You subtract that amount, in this case $500 from the $15,000. You get your subtotal then of $14,500. The law firm is compensated then 33.3% of that subtotal. Subtract that, which leaves a subtotal of $9,667. And then there's payment of an outstanding medical bill, which is $4,000. So, once that's subtracted, the net amount to the client is $5,667, all beginning from that $15,000 amount. Let's take a look at a similar scenario using 40% of the court-awarded amount. Again, total gross settlement amount is $15,000. The attorney cost and copying and court reporters' bills remains the same at $500. Subtract that to once again get $14,500. This time, though, the law firm compensation is 40%. That figure increases, making the subtotal smaller. The payment for outstanding medical bills is $4,000, remaining the same. But in this case now, because of the 40% compensation, the net amount to client is $4,700. And that wraps up our talk today on how contingency fees will affect your final settlement payout. To learn more and get a free case review, visit injuryclaimcoach.com. Thanks very much for watching, and best of luck with your case.